not capable of following probation rules. He's not capable of following parole rules.
So this sentencing involves a serious domestic violence case with a long history behind it. The attorneys argue over how the defendant's record should affect the sentence, but the emotional weight of the hearing comes when the victim speaks for herself. Watch how Judge Middleton handles the record, the guidelines, and a victim statement that's pretty hard to hear. My name is Dan. This is the Courtroom Files. And I think Ellie's either going to watch along with you or take a nap, or maybe both.
All right, welcome back. We're here on a special record of the 45th Circuit Court. This is a felony sentencing matter that I'm handling by assignment. So the court we're calling into session is the 45th Circuit Court. Prosecutor is here. The complainant is here. The defendant is here in the lockup meeting with his counsel right now, and I expect they'll be here any minute. So I'll get everything set up. Live stream is on. The record is not. But also note that this is a sometimes state and federal holiday. June 19th, the date varies from year to year, but the state of Michigan employees, including the Department of Corrections, have a vacation day today. The county employees, including all of us, do not. So we've set this for this date without thinking about whether it was a holiday, but we'll be here. I don't believe the officer will be here from the Department of Corrections. They have filed their report. I stand corrected, Sam. This form was in there. It was on the back side of another page. And I didn't realize I actually already had it. Double-sided printing. The holding facilities in this building are not adequate. I don't know what they did 100 years ago. There was no elevator. The jail was across the street in what's now an administrative building. They must have just walked the inmates over here in shackles and had them walk up the steps. There's no, maybe there was originally, but there is no holding cell. So they've got a little makeshift one, but there's no bathroom facilities. So this is not ideal for in custody defendants. We try to do as much as we can by Zoom with in custody defendants, but in a felony sentence, the defendant has an absolute right to be present in the courtroom. And unless there's extenuating circumstances, they're not to be done by Zoom. So we're going to do this live in this historic courtroom and make the best of it. Good morning, Mr. Yoder.
Okay.
All right, we will go on the record in this matter. The title of the case is People versus Timothy Yoder. The file number is 25. With my eyes here, got something that's got it better than that. 2525935 FH. The defendant is here with his lawyer, Casey Strong, also present as prosecuting attorney Angelique Camfield, who is the assistant assigned to this matter. Our complaining witness is also present, and I think we may hear from her this morning. Mr. Yoder is here to be sentenced on a felony plea that was entered on May 15th to a charge of assault with intent to do great bodily harm by strangulation as a third habitual offender. The defendant pled no contest to that charge, and the matter was set for sentencing this morning. The court has had an opportunity for a week or more to review the pre-sentence report, and are the people ready to proceed?
Yes, Your Honor.
Mr. Yoder, are you ready to proceed?
Yes, Your Honor.
All right, as I indicated, that's the charge. And we're gonna do the sentence in that matter. Before we begin with elocution and other matters, let's talk about the pre-sentence report. Ms. Strong, do you have any changes, additions, or deletions to the report?
I have no changes, corrections, or deletions to the substance of the report.
Ms. Canfield?
Good morning, Your Honor. No additions, deletions, or corrections to the body of the report. I do have challenges to the scoring of the guidelines.
All right, well, let's talk about that. The guidelines have been scored by Agent Melinda Albert in the following manner. PRV1 was scored at 75 points. Ms. Strong, do you have any challenge to that?
No challenge, Your Honor.
Ms. Canfield?
No, Your Honor. My challenges are not to the prior record variables, but to the offense variables.
All right, well, let's finish the PRVs. PRV2 was scored at 5 points. Any challenge to that?
No, no, Your Honor.
PRV4 was scored at 5 points. Any challenge to that?
No, Your Honor.
No, Your Honor.
PRV5 was scored at 20 points. Any challenge to that?
No, Your Honor.
No, Your Honor.
All right, with those PRVs, the defendant would be at PRV level F. No challenge to that.
No, Your Honor. I believe that that is properly calculated.
I believe that is accurate.
Thank you both. All right, well, let's talk about the offense variables. OV3 was scored at 10 points, alleging that the victim suffered injuries and was treated by EMS at the scene. Do you have any challenge to that?
No, Your Honor.
No challenge.
All right, OV4, 10 points, as the victim is currently in counseling. Any challenge, Ms. Strong?
I have no challenge to that, Your Honor.
Ms. Canfield?
No, Your Honor.
OV10 was scored at 10 points, as the defendant and the victim are legally married and have in the past resided together. Any challenge to that?
No, Your Honor. No challenge.
No, Your Honor.
All right, well then, that's all I've got.
Your Honor, that's, I believe that the department should have scored some additional variables that they did not,
All
and
right,
I
well,
have.
let's go through the rest.
Sure.
Because we've got OV, so there's a lot of blanks in here, but, which are you contending should have been scored? So let me, at the current juncture, the defense has no objection to scoring as in the report. Is that correct, Ms. Strong?
I have no objection to how the Department of Corrections scored in the report.
All right. Ms. Canfield, what do you think should have been scored?
Thank you, Your Honor. With respect to offense variable 13, I've previously informed Ms. Strong that I believe that should be scored at 25 points with respect to 3 crimes against a person within the 5 years preceding and inclusive of the sentencing offense. And my reasoning is as follows. It does also include under the scoring of the guidelines any cases that were dismissed.
Say that again. I didn't hear it.
It includes charges that were dismissed if they were still crimes against a person within that 5-year period, as long as there is a preponderance of the evidence that they occurred. In this matter, the first crime to score under there would be the sentencing offense, which is the assault with intent to do great bodily harm by strangulation or suffocation. The second offense would be the domestic violence 3rd degree that was dismissed as part of the plea agreement because there is independent evidence in the record and the report that was utilized for the pre-sentence investigation that the victim was previously that same day that the strangulation occurred. There was an interference where the defendant came to her home and was trying to get into her car, take her keys, and that when she told him to get out of the car, she was shoved back by the defendant, which was the basis of the DV 3rd that the people authorized and subsequently dismissed. So I do believe that there's a preponderance of the evidence that that occurred on the same day, which would also be within that 5-year period of time. The final 3rd crime against an individual or person would be alleged to have occurred on September 21st, excuse me, of 2022 in the city of Sturgis, where the defendant did plead guilty to a domestic violence count and a home invasion 1st degree count was dismissed. That stemmed out of an incident where the defendant went to the residence of Ms. Yoder. He did knock on the door, and when her daughter opened the door, he was screaming and yelling. So Ms. Yoder went to quickly close the door. And at that point, the defendant kicked open the door and it struck her in the arm, which was the factual basis that was given at the taking of the domestic violence plea for the charge he pled guilty to. But the entering into the room and the breaking in was what had supported the original offense of the home invasion 1st degree, which was dismissed. I think there's a preponderance of the evidence that that absolutely did occur, even if he did not plead guilty to it. And as offense variable 13 allows cases and charges that were dismissed to be included within that calculation, I would respectfully ask that the court increase that scoring to 25 points.
Which would do what?
Well, I have another offense variable I'd like to add.
All right.
Can we have arguments on the first one before we move forward?
Yes, let me flip to offense variable 13. Print so small. All right, well, before we get to that, how many more of these do you have?
Just one, Your
All
Honor.
right, what's the next one?
The next one is offense variable 19. I believe that it should properly be scored at 10 points for interference or attempted interference with the administration of justice. In the police report, as well as in the pre-sentence investigation, there is evidence that the defendant had like stiffened up and passively resisted getting into the police vehicle after his arrest. And although it is not included in the PSI, it is known to at least the people, and I did inform Ms. Strong by email also this morning that the defendant became quite problematic through the booking process and was very argumentative, and there was an incident written up at the jail once he was booked because of that behavior. So I do believe the passive resistance and failing to get into the police vehicle and needing to be assisted in there, as far as stiffening up his body, not sitting down as directed, in addition to what occurred through the booking process, would be supportive of 10 points for interference or attempted interference with the administration of justice. Now, should those two be granted, we would talk about a variance in the point total, which would then change the cell range and the guideline range. However, I will state that the recommended sentence of the Department of Corrections is still within that range.
All right. Right now, the guideline range is something like 29 to 85 months. There's a 72-month cap. So we're arguing about raising the ceiling when the cap is already at 72 months.
Well, and Your Honor, I should state that was not a Killebrew agreement. That was a sentence recommendation. We agreed to make a sentence recommendation that it be capped at 72 months.
So are you going to change that?
That is still our sentence recommendation.
Okay.
Not a Killebrew sentence agreement. So the court can consider that, as well as allocution from both parties, the victim's statement and the Department of Corrections representation and recommendation, before it concludes what it feels is appropriate.
So I'm not sure what that means. So your recommended cap is 72 months, but now you're arguing about a bunch of things that aren't in the record, and I have to find preponderance of evidence based on statements that you've made to the court to ask me to increase the ceiling on the guidelines while still sticking to your recommendation of 72 months. So they want me to convince me there's enough bad evidence I should exceed your recommendation and exceed the 72-month sentence?
Your Honor, that's not what the people are arguing. I simply need the guidelines for the Department of Corrections record to be correct, based upon my information and knowledge of the prior cases and the scoring of the guidelines. I still will stand by a recommendation of a sentencing cap, but that's not a binding Killebrew agreement that the court must follow. It's just a recommendation from the people, and defense was aware of that at the time of the plea. So,
and I understand that, but if I were to exceed the recommendation, I would allow the defendant to withdraw his plea, even though it's not a hard Killebrew agreement. This took me by surprise. I thought there might be some challenge from the defendant. I did not expect a challenge from the people. And as you indicate, some of the things the challenge is based on are not in the report. So I wouldn't have had any way to know some of the things that you're alleging. I was aware of the previous convictions. I handled one or more of them.
well, if I may, Your Honor, I believe that the DV third is in the report, and then the DV or the home invasion is conviction 36 of 37 for the domestic violence plea that was entered.
Yes, in fact, I printed both of those files out. So I handled those as district court. All right, we've taken a turn here. Ms. Strong, she's alleging that offense variable 13 should be scored at 25 points. What's your response?
Thank you, Your Honor. As pointed out by the court, the sentencing guidelines were done by the Department of Corrections in the normal process and presented to the court, scored appropriately. The people are now arguing for additional points to be added based on information that the position of the defense is not contained within the report, and we have no knowledge of or ability to verify. In my discussions with the defendant, I would ask the court to recognize the alleged 2022 home invasion first and domestic violence for what it was, which was a plea to a misdemeanor, and not allow those 25 points to be scored. I do not believe, based on statements made by the state rather than evidence presented, that there is a preponderance standard here. And as the court indicated, there is a cap that has been recommended by the people in this case. Similarly, for OV-19, the defense does not believe there was any indication of interference with the administration of justice. While the people stated there was passive resistance at the time of the arrest, Mr. Yoder was quite intoxicated at the time of the arrest. And passive resistance does not give information to make a determination whether or not law enforcement was interfered with. There was no resisting, obstructing charge that went along with this. This is the first I've heard of passive resistance, and I don't have a definition for what passive resistance was, and we don't have a deputy here to tell us what happened. Similarly, when he was booked in at the jail, that is all just statements made by the state. I do not have a jail incident report indicating anything that happened at the time of his booking. From my understanding from my client, who was there and present, he was placed in a restraint chair for his own safety, and he did not engage in behavior that would go above and beyond and obligate those points to be added. So I would ask Your Honor to respectfully not adjust the scoring and modify what the Department of Corrections has properly scored. Thank you.
Brief response, Your Honor.
Yes.
On page 4 of the pre-sentence investigation, it does say, while being taken into custody and walking to the patrol vehicle, Timothy became passively resistant and would not cooperate when getting into Deputy Morrell's patrol vehicle. He was also calling the officers on scene faggots and various other names. And then, of course, we know that that behavior continued at the jail. So I do think that that's properly scored for OV-19. And then with respect to offense variable 13, Ms. Yoder was the victim. Ms. Yoder is present. The court, excuse me, heard the taking of the plea of the conviction in number 36 of 37, and heard the factual basis provided that the door was kicked open without consent of Ms. Yoder, and he attempted to get in and to her, and this door struck her in the arm and caused an injury. So I do think there's a preponderance of the evidence there, but certainly I can have Ms. Yoder speak to it if the court wishes to have more.
Hello. OV-13, in the section cited, the offense was a part of a pattern of felonious criminal activity involving 3 or more crimes against a person. So I guess one of the 3 is this offense. 2 of the 3 would be the domestic violence case. That was in District Court number 22119 SM. I sentenced the defendant to 43 days in jail. File 231993 FY was a home invasion and domestic violence. I thought that matter was bound over to the circuit court. I had this up, but Judge Pattison used the courtroom. Yeah, that matter was bound over to the circuit court. so
Yes.
I didn't handle that case.
If it may assist the court, I believe that the domestic violence plea on that matter was entered in the circuit court, and along with a subsequent plea the very next day to a possession of methamphetamine charge, which I believe is in 35 of 37 as far as the PSI.
Which is not a crime against a person for purposes of OB 13.
No. The defendant was bound over to circuit court on that case. And if I understand it, that case was dismissed for a plea in a methamphetamine case as a habitual.
Not dismissed in its entirety. That's where the domestic violence plea was entered. However, Your Honor,
Also,
offense variable,
A domestic violence plea was entered in that file number in circuit court?
I believe so. It's not clear from the notes. I did not handle that.
And if it's not clear from the notes, how can we argue for OB 13 scoring purposes?
Your Honor, OB 13 does not require a conviction of the felony or the crime against a person. As counsel knows, OB 13 includes dismissed offenses against a person within that 5-year period.
But it requires a preponderance of the evidence. And if we're going back and forth about notes not reflecting, not knowing what happened or the adjudication of the case, how can that preponderance standard be met?
The adjudication of the case is reflected in 36 of 37 in the PSI, Your Honor. And with respect to the evidence, I've already stated the factual bases that the court accepted for that plea, and Ms. Yoder is present. So perhaps
Well,
we could
the
resolve
first one,
that
I
if
don't have
she
a
made
problem with it. I took the plea. So I'm familiar with the case. It's the bound over one. Let's take a look at. It's in here in the PSI. We have to find it.
Your Honor, defense counsel is trying to argue that there must be a conviction on a felony crime against a person, which is not accurate.
All right, well, I don't dispute that, but what do I do? Just pull it out of thin air because you represent that something happened? I have to make some sort of finding of a preponderance of evidence that the conduct occurred. And so if there was no conviction, I don't just assume that the conduct occurred. There has to be some sort of finding. And then we really go down the rabbit hole. We have a trial on a previously dismissed matter to find a preponderance of evidence. And it isn't. There are so many of these priors. He was convicted of domestic violence in that case, 36 of 37. The domestic violence charge was a conviction, and he spent 93 days in jail. So he has a conviction in the misdemeanor domestic violence case, 221903FY. That is within 5 years of this case. He has a conviction of domestic violence in circuit court number 22245568FH. And he has this one. So there are 3 domestic violence convictions, which are crimes against a person within 5 years. So I guess I don't need to have a preponderance finding. The defendant was convicted 3 times. Once for an incident that occurred on May 12th or something, and that's 22, and the second was September 21st of 22. And this case. So I find that the prosecutor is entitled to have 25 points scored for OV 13. The cap remains the same. And the police report does reflect that the defendant did passively resist and was very disrespectful to the officers. And I believe OV 19 also merits a scoring of 10 points. So let's figure this out.
Your Honor, I think by way of those being added, then the OV total would increase to 65 points. And the offense variable level would increase to 5, which would be a guideline range of 38 to 114 months as a habitual third offender.
All right, so let me change the report. OV 13 is now scored at 25, and OV 19 is scored at 10. The total is 65 points. And the offense variable level is 5. And the guideline range is 35 to 114 months. And we still have a 72-month cap as a recommended cap from the prosecuting attorney. All right, I've made a ruling on those arguments. They're certainly subject to further review. Having said that, Ms. Strong, what would you like me to know in your elocution?
Thank you, Your Honor. As indicated in the report, Mr. Yoder is familiar with the criminal justice system. Mr. Yoder, if he were to speak today, I'm sure he would state this as well. Mr. Yoder has an alcohol problem, not a bad person problem, and he allows that alcohol problem to cause him to engage in behavior. He is not before the court today to minimize anything that has happened or anything that occurred during the sentencing offense. He takes full responsibility for what happened and stands before the court ready to face a substantial punishment for his conduct. While he's been in jail for 200+ days. He's taken that as the opportunity that it is. He has been sober. He has been completing classes through the jail to try to better himself, to stay busy in the jail, and to allow him, once he is out of prison, to reacclimate to society in a more productive way. He is engaged substantially with the pivotal recommendations and the representative that is here and present today, who I'm sure is willing to speak to that engagement if the court so chooses. Mr. Yoder has taken this as the opportunity that it is, and I would ask the court to see all of that mitigation that he has done since the sentencing offense and let that reflect in the sentence of the court and sentence him to the low end of the guidelines. Thank you.
Thank you. Ms. Campfield?
Thank you, Your Honor. Very briefly, I just want to reflect for the court that on page 2 of the pre-sentence investigation, the court would also need to correct the scoring range and the offense variable total to 38 to 114 months and then 65 for the total. I just want to make, thank you. Okay, perfect. Now, with respect to this matter, the court heard the plea and has had an opportunity to review the pre-sentence investigation report. I have had an opportunity to speak with Ms. Yoder, who did agree with us allowing the recommendation of a cap at 72 months. We do recognize that the recommendation of the Department of Corrections is higher than that, and we'll leave that to the court's determination of what it wishes to do. However, with respect to the counseling and services the defendant has availed himself of, I would just ask the court not be inclined to mitigate because of the therapeutic process. Unfortunately, the defendant is a bad person. He makes poor decisions, he makes criminal decisions, and he's done so since a juvenile. He has had repetitive contact with the law. It's been violent offenses, drug offenses, home invasions, domestic violence. Consistently, that behavior is not all because of alcohol or substances. Those may contribute to that. They may be a factor in that, but his character and personality and choices also play into his criminal conduct, Your Honor. And it's not abnormal for a defendant who knows they're facing a fairly long prison term to avail themselves of services to try to argue then that their sentencing should be lower than what the recommendation is or what the people's capped recommendation is. Mr. Yoder has demonstrated repetitively over the years, as reflected in the pre-sentence investigation report that was prepared by Ms. Albert, that he is not capable of following probation rules. He's not capable of following parole rules. He has violated them a multitude of times, and those eventually result in a revocation of prison and of parole and a revocation of probation in multiple instances. Particularly if you look with, let's see, on page 13 of the pre-sentence investigation in conviction 11 of 37, he had a probation violation in November, was arrested and sentenced to jail. He had a probation violation in August of 2 years later, was arrested and had another pending probation violation outside of the state in Indiana. He wasn't able to comply with that probation. When you look further into, a lot of these may be traffic violations, but when you look at his methamphetamine cases, I'm trying to get to the page, 23 of 37 on page 18 of the pre-sentence investigation shows he gave benefit of the special incarceration, was paroled, absconded from parole, arrested, parole was reinstated. He was arrested again, it was reinstated, arrested and reinstated, absconded again, absconded a third time, absconded a fourth time, and eventually had the parole revoked and then was discharged after multiple abscondings and reinstatements. When you look further into page 22, conviction 32 of 37, again, probation violations a multitude of times, then finally sentenced to prison and paroled, then violated parole, was given warnings, went AWOL, didn't stay at the Twin County Probation Center. Like, we just have continual issues with him throughout the years. And again, bond violations in 2022, discharged from parole unsuccessfully in 2021, parole violations and probation violations in 2023. I mean, it's just his habit. He does not wish to avail himself of the services once he gets parole or probation. My submission to the court is that his engaging in these counseling services and having the additional report added by Ms. Albert that he's been engaged at Pivotal is just his attempt to show the court that he can do the services. He can be present and in attendance and presumably be making progress towards his treatment goals. But it's to no benefit, Your Honor, because he doesn't take it to heart. It doesn't change his behavior. It doesn't make him less violent. And it doesn't encourage him to remain sober. So I think all of those things taken into consideration, the people are asking for a recommendation or a sentence within the guideline range that it be 72 months to 114 months. Well, actually, it'll be to the max, but at least those 72 months, Your Honor, is what the defendant deserves for this conduct. Ms. Yoder was choked to the point she was almost unconscious. She feared for her life. She was frightened, so frightened to testify at the preliminary examination that I utilized only the trooper's testimony and her excited utterance statements and the reflection of injuries to bind the case over to circuit court. She is here today with support persons, and we would ask that the court allow her to speak as to how these matters have affected her.
Ms. Yoder, would you come up and have a seat with the prosecutor? We've met, but you're Angela Yoder,
I am.
and I'm glad that you're here today. I saw your original victim impact statement, and it was pretty vague. I'm not sure what a proper sentence should be. I
Right.
think he should admit to his actions and get help. That was from May of 26. You were the victim in the earlier cases. I
Yes.
handled the one and we talked about it back in 22. I think you were here for the sentence in that case. Anyway, here we are again. What would you like me to know?
I would like you to know that even though it's been said that he is a horrible monster, whatever, he's not that way all the time. He's not. He does give in to desires on alcohol, and that turns him
Well,
into,
let me stop you for a minute. We're talking about alcohol.
yeah,
What about methamphetamine?
that was years ago.
2009 meth lab, 2009 meth lab, maintaining a meth lab, 2016 possession of methamphetamine, 2018 possession of methamphetamine, obstruction of justice, 2022 possession of methamphetamine. That's 1, 2, 3, 4, 5 methamphetamine cases.
Yeah.
Methamphetamine changes your personality, it
absolutely does.
distorts your brain. We're talking about alcohol. There's a big pink elephant in the room, which is methamphetamine.
That he goes from when not doing drugs, his next go-to for something is alcohol.
All right, so during this period, and the defendant pled no contest because he doesn't have a clear recollection. This incident, you believe, was alcohol focused?
Yes, absolutely. Earlier in the day, he took the car, he was out drinking, and then the cops took him home, took him to his house, and then he came back to my place later on that night, and that's where this all started.
Yes, the report reflects that. He was there drunk, causing a ruckus.
Yes,
Went home because the police took him home.
yes,
And then he came back and here he is seated in a green jail suit.
yes,
All right, so this was not meth-based, but alcohol-based.
yes, he was drunk. He was
Okay.
absolutely drunk.
And he acknowledges that. So go ahead.
Well, then, oh, I don't know what else to say. I mean, a lot of things happened that night. I begged him to leave. And it just seemed to make him more irate. And then he drew back like he was gonna punch me. He did not, thank goodness. And he grabbed me by my throat and slammed me up against the wall. And I was on the phone with 911 the whole time. And then when he let go of me, he ran out of my apartment out into the woods.
Well, you said at one point you thought you were gonna die.
Yeah, I could, like, it was fuzzy. I couldn't breathe. I could see little dots. He was mad and he told me, he yelled in my face, "You are gonna die."
What was he mad about?
I'm not exactly sure. I don't really know. I know he wasn't himself at that time. But he was angry.
Now, Ms. Camfield said, and I have reason to disbelieve this, but they discussed this with you at the time of the plea and this 72-month cap. That was something the prosecutor shared with you, and that was something that you would accept as a resolution of this.
Because I don't know how it all works. Yeah.
Well,
I don't think he needs to spend the rest of his life in prison.
all right, that's fair enough. I had taken this case as a case that would go to trial. I volunteered some open dates and I had several cases that were set on my docket. And most of them were resolved, and then I ended up with this case, which was okay with me. I've known Mr. Yoder for a long time. And many of the things Ms. Canfield has related, I was in on as the judge. And I've known you since that earlier hearing. Again, you're willing to accept their 72-month cap recommendation?
I don't even know how long 72 months.
That's,
6 years.
it's about
6 years, Your Honor.
6 years
I believe
to
it.
114 months. All right. You and the defendant do not have any children in common, that's correct?
Right.
But his children, your children have been part of his life. So
Yes.
he's been a parental figure to your kids.
Yes.
None of those kids were present when this incident took place.
Just last time?
Yes,
No.
all right.
No.
Is there anything else you'd like me to know?
I just kind of, because of the fact that 3 years to the date when this happened, 3 years before is when the last one happened. And then exactly 3 years later, it happens again. And this time he put his hands around my throat and told me, I want you to die. You are gonna die. And I believed him. As much as I love him, I really truly believe he would have killed me that night. I promise you, I do. And I fear him. I promise I fear him. Because if after 3 years, you're still mad from 3 years before and it happens again, what's gonna happen in 3 more years?
Well, this one, there was one in May and then there was another one in September.
Yeah,
That was in the earlier ones, but this one, you're right, about 3 years from ago.
yeah. I'm just afraid. I don't want all bad to happen to him. I do love him, but I love me too. And I am afraid.
All right, I certainly understand that. Mr. Yoder,
Yes, sir.
I'm glad she's here and I'm glad you got to hear that. It was hard for her to say.
Yes.
She loves you, but she's afraid of you. And to your credit, you accepted this plea deal and just said, I don't remember what happened. And I accept responsibility, and you accepted the plea and left it up to me as to what to do for the sentence. Could you move, or get another set of Kleenexes? Give her some and he can have some. All right, Mr. Yoder, what would you like me to know?
Your Honor, I would like to first start off with everything that Ms. Canfield had spoken about my past. Every bit of it is true. I'm not sitting here trying to negate the fact that I'm responsible for this. But at the end of the day, we're human beings. We make mistakes. Some learn tougher lessons than others. I'm learning every bit from my mistakes. I wish there was more that I could allocate to the court and to my wife. About that night. I can't. You know, I'm not worried about the sentence. I'm at peace with it. I've hurt my wife. Not looking, excuse me. I've not seen, I've not been able to see beyond the end of my nose, we'll say. And my actions It's not an excuse. It's not an excuse. But I'm striving every day to make myself better. You know, if this marriage were to end right now, it's not gonna stop me, you know? If I'm not good for me, I'm not good for anybody, you know? You know, and so I respect my wife for coming in to the court today. I take strength and bravery. Not a monster. I've done some crazy things. I'm not a monster. And I'm just gonna accept whatever it is that the court decides as a proper punishment and move forward. And just strive to be better, realize my shortcomings from my past mistakes. You know, I'm getting older, you know.
How old are you?
42. I'll be 43 this year.
Well, I didn't meet you until you were an adult,
Yeah.
so you were in open intox or something was the first thing we had, or a minor in possession. You were
I've had a whole
18.
my whole life has been substance related. It's been substance fuel. It's not an excuse. Got a lot of hurt, a lot of trauma, a lot of baggage from my childhood, you know, didn't want to face it. But today sitting here, like, this is ridiculous. You know, this is ridiculous. I'm in front of the court again. Where I thought I would never be sitting here again. You know, I really didn't. I'm here. And it's time to just, you know, I accept responsibility. I cannot allocute to what happened that night. I wish I could. And I'm just ready to get this chapter behind me.
I would ask you what you were mad about, but you probably don't remember.
Your Honor,
what you're mad about is life.
I don't know.
Your whole life is a angry response
Terrible
to the baggage you're carrying around, and you took it out on the person that loves you more than anybody else.
And can I say one thing to my wife? That I just want to apologize. You know, I never meant for our lives to turn out this way, but it happened still, you know, and I'm sorry.
Well, you've had a number of other relationships and children with other people, and this relationship, I think, is one of the longest ones you've been in, and the one you were in at this time. And she said she loves you.
Yeah.
But she doesn't like this version of you.
No, I don't like that version of me.
And we had about 44 entries in the district court record regarding you. But you have some stuff in other jurisdictions and some juvenile stuff. And there's a lot of background. 5 felonies and 31 misdemeanors, I think, is where we were. And I read the report multiple times, and I couldn't find anything positive. We tried everything. We tried district court probation. We tried swift and sure. We tried drug court. We tried the probation center. We tried incarceration in prison. All the programs we have, domestic violence treatment, Twin County Community Probation Center, swift and sure, drug treatment court, all those have been utilized. And you're still like a Tasmanian devil spinning wildly out of control, bringing chaos because you're so angry you can't contain all your own anger. In one of the earlier cases, the prosecutor asked for 93 days, and I gave you 43 days after hearing everything. I don't know that 93 days would have made a difference. And there were a couple of things after that. I think at some point in the last few years, you put methamphetamine aside and traded it for large self-medications of alcohol. I said there, I couldn't find anything positive. Then I got an addendum. Dated 6/15/26. Since the submission of the pre-sentence report in this file, the writer has been advised by Lauren Frank Pivotal that the defendant has engaged in mental health services since October 16th of 2025. Ms. Frank indicates that Yoder voluntarily sought treatment on his own and has demonstrated consistent and active participation. She further notes that Yoder has made measurable progress toward identified treatment goals. So that's been since you've been locked up. And I don't take it cynically. I think that you probably are sick and tired of being sick and tired. And you have availed yourselves of the services that were there at the jail with Ms. Frank and with Pivotal. Which I say good. So I did find one little ray of sunshine at the end. You're not a monster. You're a human being. You're a person. And you've done awful lots of bad things, including make the woman that loved you think you were going to kill her. Your guideline range is near as bad as any I've seen. And my fear was at some point, you are going to kill her. Not because you're mad at her, just because you're mad at the world. She didn't deserve the wrath of that. After hearing argument from the prosecutor, I've increased the top end of the guideline range to 114 months. The original recommendation of scoring was 29 to 85 months. But constant in the matter was the 72-month sentence recommendation from the prosecution that was made with the consent of Angela Yoder. So it is my sentence that you are sentenced to 72 to 114 months jail. There's not a departure of the guidelines. Prison, excuse me.
Your Honor, respectfully, I believe the court wants to put the minimum guideline range is the what's reflected in the 38 to 114, but the maximum he faces is the 20 years.
114 months.
So he has a 20-year tail though, Your Honor. So I believe the sentence needs to be the 72 months to 20 years.
Well, the guideline range we'd established is 38 to 114 months.
Correct, Your Honor. But in the felony sentencings, the tail is always stated by the court as the maximum he could face if
I
he
see.
violated parole,
All
things
right,
of
I
that
got
nature.
you. All right, so it's a
Yes.
20-year thing, 72 months to 120 months. Thank you.
It's actually 20 years.
Oh, so 240 months?
Yes. And then also if the court hadn't, I don't recall if I heard it, the reflected credit of 271 days.
272 days. I haven't gotten that far yet.
Okay.
But the report says 271. The jail roster as of yesterday says 271. So he has credit of 272 days.
Thank you, Your Honor.
All right, there are also some fines and costs which have to be assessed. got this court order. Tore it apart. The also assessed are the required fines, a crime victim assessment of $130 and $68 in state costs to the state as required by statute. You do have a right to appeal this matter. You're entitled to appellate review of your conviction and sentencing. This is done by filing a claim of appeal by right when you're convicted by trial, or by leave when you're convicted by plea, which is what this is. This will tell you that if you cannot afford to hire an attorney to represent you on your appeal, you may request the counsel be appointed. You may request an attorney by completing the request for appointment of attorney section below and return the form to the court. I'm going to ask you to sign one and make that part of the file, and you keep the other two if you wish to pursue that avenue. Yes, thank you. The maximum sentence is always the ceiling. If we omitted anything we think should be a part of this record. All right, according to the clerk and administrator, we have not. Ms. Canfield, anything else you wish to add to this record?
No, Your Honor, only just to state that as the court just did, it gave the defendant his appellate rights, that an appeal of a plea of guilty in sentencing is by leave of the higher court. Thank you, nothing further.
Those appellate rights have been returned and will make a part of this file. Ms. Strong, anything further?
Nothing further, Your Honor.
Mr. Yoder, all you can do is try to be at peace with yourself. You're going to have some time to think about it. I wish you the best of luck. Good luck, sir.
Thank you, Your Honor.
So the part that stands out here is the victim trying to hold two things true at once, love and fear. That is exactly why these cases are so difficult and why the court has to look beyond what anyone hopes will happen and focus on safety. But I'm curious to know how you see it, so take a moment and let me know down in the comments. And oh, by the way, we speculated at the beginning of this video whether Ellie was going to take a nap or watch along. You don't see her here, so she opted for that nap. Do me a favor, though. Check out one of the two videos that are on your screen. I'd really appreciate that. And thank you so much for watching.